Hello and welcome to the first of a series of GasFields Commission webinars. We are broadcasting to hundreds today, which is fabulous. We hope it's equally fabulous for you all. My name is Jane Walker and I'm the Stakeholder Engagement Manager with the GFCQ and will be facilitating today's session along with our Senior Media Communications Officer, Andrew Musgrave. Before we commence, I would like to respectfully acknowledge the traditional owners and custodians of the land on which we meet and elders past, present and emerging. We have 4 subject matter experts online today who are representatives of DES, Department of Environment and Science, Department of Natural Resources, Mines and Energy, the Land Access Ombudsman and the Land Court of Queensland, who will be speaking on topics relating to land access. The presenters will be speaking for approximately 10 minutes each. At the conclusion of the event, we will conduct a Q&A session. So let me set the scene. I understand we're not today's main event, but important for you all to know a little more about the Commission. The GasFields Commission is an independent statutory body and came into effect on the 1st of July 2013. We are a team of 10, which consists of a CEO and 4 teams: policy and projects, communications, corporate governance and engagement. Our legislative functions can be broadly summarised as facilitation, which is face-to-face, group meetings, webinars, etc., like today. Review, which means we look at the effectiveness of the regulatory framework. And advisory, ministers, governments and the onshore gas industry on matters relating to coexistence and leading practice. The slide on the screen, this just gives you a visual of who we work with. Okay, so us being the independent body, along with the Land Court of Queensland and the Land Access Ombudsman, sits there in the middle. We work with all of these departments. On your left is all of the government departments we work with. 2 of those departments today will be speaking, which is the DNRME and the DES. And on the right, which is equally as important to us, is working with landholders, community groups, resource companies, local government, Chamber of Commerce, peak bodies, APIA, QRC, QFF, AgForce, Cotton Australia, and research organisations. So just quickly, in this slide, we're just presenting the topics that the GasFields Commission have recently identified through our stakeholder engagement activities. Please note, though, today's webinar will be focusing on the issues and processes relating to land access. The other priority topics listed here will be addressed in our up-and-coming webinars. It is also important to note what the GasFields Commission doesn't do. We do not become involved in individual negotiations and investigating complaints made against individual gas companies. We do provide education, though, through tools and facts to enable informed decisions, compiling and distributing information about the onshore gas industry via the Commission's website, publications, information sessions, meetings and online webinars, much like the session today. Connecting with stakeholders through genuine engagement, encouraging clear and transparent communication, and identifying emerging issues and bringing together relevant stakeholders and subject matter experts to investigate options. In conclusion, the GFCQ's purpose is to manage and improve the sustainable coexistence of landholders, regional communities and the onshore gas industry in Queensland. So with that, we might launch straight into our 4 fabulous speakers. And today, the first speaker is Kerynne Birch, who is the Director of Energy and Extractive Resources Assessment Team within the Department of Environment and Science. Kerynne has 17 years' experience in state and federal government regulatory roles. She leads a team of 25 environmental officers who undertake assessment of a number of activities such as petroleum and gas, power stations, quarries, sugar mills and timber mills.
Thanks very much, Jane, for the introduction, and thank you to the GasFields Commission of Queensland for having me today. Thank you for everyone who's logged on today and joined us online. This is a great way to try and connect whilst still social distancing, so thank you. I won't say anything more about myself. What I'll launch into is what I'll be talking about today. So I'll be talking about who the Department of Environment and Science are, what we do and how we do it, And I guess something that's relevant to today's discussion and of concern to you is how you can have a say in the environmental assessment process. So first up, a little bit about the Department of Environment and Science. So we're a diverse department that brings together responsibilities across the environment, heritage and the arts. Now, I don't know much about heritage and the arts, but my business is in the environmental realm as the environmental regulator. So our key responsibility in this space is regulating companies to ensure protection of the environment. And the key way we do this is through environmental permits, otherwise known as environmental authorities. It's worth noting at this point that the environmental authority is issued pretty early on in the process to an operator, and is actually a requirement before an operator can have tenure issued.
No, the next one.
On that, I just wanted to mention that DES and the Department of Natural Resources, Mines and Energy work together very closely to regulate the petroleum and gas industry. DNRME has key responsibilities relating to tenure and access to land by resource operators, and DES complements this by regulating the impacts of the resource operators on the environment. DES and DNRME work proactively to ensure that it's easy for you to have your concerns heard in relation to the petroleum and gas industry. So a couple of ways we do this is by having a single point of contact via DNRME's Resource Community Info line, and you'll hear a bit more about that from Steve Ward later on. We also conduct joint inspections of operators together where appropriate, and we also try and share information to ensure we have the full story when we're regulating activities in the petroleum and gas sector. So up on the screen there, you'll see a little map. DES has offices throughout Queensland where we effect our responsibilities from, but the regulation of the petroleum and gas industry happens predominantly from Brisbane for assessment, and the compliance framework is conducted primarily out of Emerald and Toowoomba. Next slide, please. So how do we regulate the industry? We do this through regulation of tough laws to protect the environment from impacts from resource activities. So this is done by assessment, compliance, investigations and enforcement. The key bit of legislation that we use for the regulation of petroleum and gas is the Environmental Protection Act. So before operators can commence a petroleum and gas activity, they're required to go through an intensive application and approvals process and meet stringent requirements. So the requirements will change depending on whether the activity is exploration, development or production. And once that assessment has been undertaken under that legislation and the operator has satisfied the requirements of the legislation, they'll then hold an environmental authority to undertake the activity. So the other key piece of legislation that we use to regulate the industry is via Chapter 3 of the Water Act. So this regulation occurs concurrently with the requirements of the environmental authority and includes assessment and compliance against key activities, which relates predominantly to regulation of access to underground water. So we do this through underground water impact reports, baseline assessments, bore assessments and make good agreements. It's worth noting at this point that for make good agreements, there's a different dispute resolution process to land access, and DES's key role in the make good process is ensuring that operators enter into make good agreements after completion of bore assessments. Next slide, please. So a little bit more on how we regulate the industry is through compliance and enforcement. So DES has the ability to impose significant penalties on companies who breach their environmental approvals or the requirements of the Water Act. So DES can also cancel or suspend environmental authorities if warranted, or direct operators to undertake actions under the Water Act, such as directions to undertake bore assessments. DES has recently published our annual strategic compliance priorities. These are available online via the link below, and there's also a bit of a probably hard to read picture up on the screen there of the compliance priorities. However, in 2020-2021, DES is going to have a focus on the regulation of the coal seam gas industry. So this means that DES is targeting specific aspects of this industry over the next 12 months. Next slide, please. So I'll start talking now about how you can have a say in the environmental assessment process. I know today's the theme of today's discussion is around land access, and it's worth noting that DES doesn't play an active role in the land access process. However, we, as indicated before, we do work really closely with DNRME, so if questions do come up during the land access process that relate to environmental issues, we're more than happy to make contact and answer questions that you may have. What I would suggest to you when you're going through the land access process is to ask about your environmental authority. The operator will have their environmental authority by the time they talk to you about land access. So if you do have any concerns about specific issues to do with the environment, it's worth having a discussion at that stage and seeing what's in the EA, seeing what needs to comply with, and yeah, having that discussion at that point. And if you've had that discussion and you have further questions, a representative from DES would be more than happy to speak to you about the responsibilities of the operator under the environmental authority. My teams in Brisbane undertake all assessments of actions relating to petroleum and gas industry companies in Queensland. The key role here is assessing expansions to existing production areas, as the majority of major projects have gone through an intensive environmental impact assessment and have commenced operation under the environmental approval. So that means that the majority of applications that we assess are amendments to existing environmental authorities. So the company who's applying for the environmental authority needs to demonstrate that they've complied with these requirements in the legislation before we can continue assessing their application. So I want to talk just a little bit about how we consider your submission. Essentially, we consider it against what we need to when we're making a decision for the environmental authority. For example, if a submission raises a concern about noise, the officer that's assessing the application will consider the submission against the information that's provided by the applicant, the performance requirements of the legislation and how that application has been assessed, and the types of conditions included to manage that concern in the environmental authority. The officer will then determine if the concern has been sufficiently addressed to meet legislative requirements. It's worth noting that if you make a submission on the environmental authority, it means that you have a status under the legislation of being potentially a dissatisfied person under the legislation. So that effectively means that you have an opportunity to request an internal review of the decision once it's been made by the decision maker. This means, so if a request for an internal review is made by a submitter or another entity that's considered to be a dissatisfied person, that decision will be reviewed by another officer that's of a similar level to the person who made the original decision, but has been removed. It hasn't had anything to do with that decision. So essentially they're an objective party that undertakes that review. The reviewing officer may confirm, revoke or vary that original decision that was made. Additionally, a dissatisfied person may appeal a review decision in court. And I guess I'll just round up the submission process to say that if you need assistance with the public notification process. So I want to talk a little bit now just around how information is available that's kept by the department. So our legislation requires that we need to make information available by a public register. There's a bit of a list of things up there that it's not a complete list, but it's probably the key things that are of interest. And on the right-hand side there's a bit of a screenshot of where the information is stored on our website. There's also a link below of where you can find that information. Anything that's not available on the public register is available via a right to information request that you can seek through the department. Also, just wanted to quickly mention Queensland Globe. So if you're trying to find out any information about your land and if it's subject to an environmental authority, Queensland Globe is a really good resource to and easy to use to try and find that information. There's some really good information on YouTube about the use of Queensland Globe. When I was putting this information together, I actually used the tutorials to try and make it work myself, as I don't use it that much anymore. And it was really helpful in being able to use it. I will mention that Steve Ward is going to talk about GeoRes Globe, which is a similar product, which has similar layers, but has more of a mining and resources focus. So there's a couple of tools there for people to use to find information, and both just as easy to use. So I just want to finish up with a bit of information about how you can contact us. So all the details are up there if you have any sort of concern about the regulation of the industry. However, there's nothing stopping you from coming direct to DES, and there's a couple of options there via either email or the 1300 number, and a couple of options for you to select. So that brings me to the end of my talk. Again, thank you very much to GFCQ for having me. It's great to try and connect in this way. It's all a bit new and novel for everyone, and yes, thank you again for your time.
Thanks, Kerynne. Okay, following on to our next speaker, which is Dr. Steve Ward. He's the Director in Geo Resources within the Department of Natural Resources, Mines and Energy. Steve has worked for state government in community engagement and compliance around resources for almost a decade. Steve oversees teams focused on resource community engagement, inquiry and complaint management, and compliance across petroleum and gas, minerals and coal sectors statewide.
Thanks very much, Jane. So as Jane mentioned, I'm a Director in Engagement and Compliance Unit within the Department of Natural Resources, Mines and Energy, or DNRME. Today I'm going to be speaking about some overview of the land access framework in Queensland, but before that I'll also touch on a little bit about what our unit does. So engaging with the community and other stakeholders and undertaking compliance activities is a critical role of DNRME. Ultimately, we want to ensure that Queensland's resources are managed fairly and responsibly and build awareness and preparedness among resource communities. So to do this, we have an engagement and compliance unit amongst other areas of DNRME that all play really critical roles in making sure that these resources are managed responsibly. So the engagement and compliance unit, as you saw, on the previous slide, we have people all over the state. We are, I guess today I'll talk about three key components of what we do. Firstly, with regards to inquiries and complaints. So as Kerynne rightly mentioned, we have a dedicated phone and email service, the Resource Community Info Line. And that's been in play since late 2010. Initially really focused around CSG. Now, alongside our role is not just within petroleum and gas, but also coal, minerals, fossicking. So we have quite a broad remit. And today, obviously, I'll be focusing on the petroleum and gas side of things. In terms of what we get through, the sorts of inquiries and concerns that we hear on the info line, it can range from the most simplest of inquiries, which I'm more than happy to help with, all the way through to quite complex matters sometimes. And whatever we can do to answer the question there and then, we will. Occasionally we'll need to take it away and do a bit of research to get back to you, but we'll commit to keeping you, a landholder or any inquirer, in the loop along the way. And sometimes there'll be other areas that we'll need to coordinate with. As you're probably becoming aware, if not already aware, There's different agencies that have a role in managing the petroleum and gas industry in government, and so we work very closely with the people you'll hear today, and particularly Des. You can imagine that there's quite a bit of interrelationship between the environmental side and the tenure side. And I guess on top of that, you'll also hear today a few of the different contact details, but I'd like to stress there's no wrong way in terms of inquiries or complaints. We're all working together. So if, for example, if an inquiry comes in to us or a complaint, if it's not sitting with us, then we'll take that away and we'll get it to the right person. So you don't have to try and navigate your way through Queensland Government. We're happy to do that bit of heavy lifting for you. I guess our second aspect of what we do that's relevant for today is around the proactive engagement. And today's a great example of that. We do other targeted delivery of information sessions, question and answer panels on key topics. We regularly attend large events such as Farm Fest, for example. And we obviously engage with different stakeholders such as local governments, peak bodies, NRM groups. And thirdly, a very critical role we have in resources compliance, and particularly in the petroleum and gas space, our unit really looks at the land access space. So we work with industry to ensure that they're fully aware, they've got the support, guidance and the information necessary to understand the regulatory landscape in which they're operating. But it also means that we can hopefully catch any issues early by being aware of what's going on in the tenures. We want to make sure that our approach to compliance is always risk-based, transparent, consistent, independent, proportional and fair. And I'll just do a bit of a plug at the moment for a couple of new documents that we have out very recently. This is available online. I think with all of the documents I'll raise today, they should all have a little URL beneath it, so feel free to have a look at those. But we have a new compliance framework and strategy, and this is DNRME wide. So you can see the basic framework, the framework in which we're looking to progress our compliance approach within. Now, a component of our proactive and reactive space in compliance is around inspections, both desktop and field audits. We work closely with our assessment hubs to ensure that the activities align with their priorities and are risk-based. But we also have authorised officers under the different resources, including the petroleum and gas legislation. So that may lead where there's potential non-compliance investigations. We have mentioned a number of authorised officers under the resources legislation that have those powers to investigate and address potential non-compliances. And applications include detailed development plans and work programs that comply with petroleum and gas legislation. If a resource authority approval is given, the successful applicant will work under a permit that is scaled according to the life cycle of the resource development. So, for example, exploration permits are issued for finding out what minerals and gases exist in a particular area of land, the quality and quantity of those deposits, and to determine if it's economically viable to extract and commercialise the resource. It also helps improve our knowledge, the state's knowledge of an understanding of the resource base. So those production permits for petroleum are called petroleum leases, whereas for exploration, it's authority to prospect. Other petroleum and gas authorities may include licenses for pipelines, facilities and information gathering. So holders must comply with the authorised activities, any specific conditions attached to their authority, and other requirements such as land access and environmental protection that Kerynne has talked a bit about. So throughout that project life cycle, resource authority holders are also required to lodge statutory notices and reports relating to those resources activities. So there's an ongoing requirement for the resource authority holders to be able to report back to government and for us to understand the nature of the activities that are occurring in the tenure. So these include notices and reports relating to land access, geophysical activities, drilling, administration, safety and health, environmental. So a key part of the resources regulatory framework in Queensland is the land access framework. It establishes different requirements and rights for landholders and resource companies, depending on the impact of the authorised activities being conducted under the Resource Authority on the land on which the activity is being carried out. So, for example, requirements for preliminary activity, this is minor or no impact on the land use business activities, such as survey pegging, for example, they will have a notification requirement on that. And I'll talk about that in a short while. Where they're affected by resource company activities, landholders are entitled to know what activities are being undertaken. They're entitled to provide feedback into the processes associated with advanced activities, so those activities that have a more than minimal impact on the land and the business, to the extent that they relate to the landholder. So, for example, conditions in access or infrastructure layout and so on. So now a bit about the Land Access Code. So the code contains best practice guidelines and mandatory conditions related to land access. It's a condition of resource authorities to comply with the mandatory conditions of the code. Mandatory conditions address numerous issues such as access points, roads and tracks, livestock and property, and preventing the spread of declared pest species. The code is complemented by a guide to land access in Queensland, which was shown on the previous slide, and both of these you'll see the URL beneath if you want to go into a bit more detail. So in terms of entry to private land for preliminary activities, those are the nil to minimum impact. After entry, the resource authority holder is required to provide the landholder with an entry report, and this is generally 3 months after the period stated in the entry notice. But this can differ if any waivers have been agreed between the landholder and the resource company, for example. Unless each landholder and the resource company otherwise agree in writing, the maximum entry period for preliminary activities is generally 6 months, where entry is for an exploration resource authority, and 1 year, where the entry is for a production resource authority. It's also worth noting that the first entry notice issued must be accompanied by a copy of the relevant resource authority, Land Access Code, any relevant environmental authority for the resource authority, and any code of practice made under the relevant Resource Act. Companies can only conduct preliminary activities listed on the entry notice and must adhere to the Land Access Code. However, a landholder has no right to object if the entry notice is valid for undertaking preliminary activities. So moving on to advanced activities. So these are activities that have a bit more of a minimal impact. So things like drilling, for example. So here, resource company cannot generally enter private land to undertake advanced activities unless they've entered into a conduct and compensation agreement, or a CCA. Entry notice is still required unless it forms part of the agreement. So there is a statutory graduated negotiation and dispute resolution process, and this is shown on the right-hand side of the screen. So you can see there that it includes a negotiation notice phase. There's 20 business days, a minimum, where that negotiation can occur. And then if there's any issues, any problems, any sticking points in those negotiations and the development of that CCA, or the finalisation of the CCA, then there's alternate dispute resolution. There's an arbitration pathway as an alternative to the Land Court as well. So there's lots of ways to progress this. But I should say that in many cases, this statutory process is much of it is done informally. So we see a lot of the negotiation done before it gets to this stage, and that's good. It means that communication is good, and that's what we'd like between the landholder and the company. After a CCA is in place, those agreements are recorded on the titles registry, and so that's normally has to be done within 28 days of that agreement being put in place. It's not an agreement in full on the titles registry, but rather a note that the agreement is in place and signed off. The resource company is required to pay negotiation and preparation costs that are necessarily and reasonably incurred in the negotiation of the CCA or deferral agreement. This includes accounting, legal, evaluation, and an agronomist. We recommend getting on the same page early in these negotiations. All parties are clear about how the negotiations will progress. Where a resource company decides not to continue with the CCA, the landholder is still entitled to recover necessary and reasonable costs of the negotiations. CCAs can also include other agreements. So, for example, easements and so on. But I must stress that this process is different to a compensation agreement for mining leases and mining claims. And I won't go into that at this stage because we're really focused around the petroleum and gas space. But feel free to give us a contact, and I'll provide those links later on in the slide deck if you've got any questions in a mining space, a mineral or coal space. It's a quick overview I've given you of the land access framework in Queensland. If you're interested in more details, I strongly recommend you check out those links to the documents throughout my slideshow. Also, give our people a call at the Resource Community Info line or email, and we'll be happy to help where we can or any inquiries or issues that might arise. From a, troubleshooting perspective, we often act as a conduit between parties where communication is getting a little strained or maybe even broken down, and just to try and help reset that relationship. So I just have to stress that in terms of the dispute resolution side of things, we don't have a formal dispute resolution role. Historically, we have done. We do not at the moment. So in terms of that CCA process, that flowchart that I showed a few slides back, we can only act informally in that space. Now that's a little bit different to the groundwater space, and Kerynne mentioned earlier on that it is a different process involved in terms of the negotiation there. And in that space, under the Water Act, we have authorised officers that we're able to pull the parties together for a formal conference, should it be needed, as part of a alternate dispute resolution way forward. So before I wrap up, I just wanted to quickly mention a couple of online resources, and Kerynne mentioned a little bit earlier the Queensland Globe. So and also the GeoRes Globe. So as Kerynne said, it's a fantastic mapping application, and similar to the Queensland Globe is as well. In look and feel, it's very similar to the Queensland Globe, but this is more focused around mining and exploration data across Queensland. It replaces Mines Online Maps. Some of you might have come across that in the past. It's got some really cool features. So it's got things like geological and geophysical data, current and historical exploration and production resource authorities, native title. You can run intersects across operations and reports. And it's got links to various resource authority reports, access to spatial data from QSpatial, and access to company exploration reports and data via the new Geological Survey of Queensland open data portal. So there's a lot of really good stuff there, and I really encourage you to have a look at it. And the links on the screen there will help. And similar to Queensland Globe, there's a lot of help and tutorials around, and you can see on that URL on the screen there. It's completely free to use, and you don't need to register, similar to the Queensland Globe, and I encourage you to use it. The other thing I just mentioned quickly is in terms of the reports you can run on resource authorities, and that link there, you can run it on lot plan, you can run it from a regional local government scale, and that'll take you through a whole lot of information it will produce for you. That will give you information about what applicable resource authorities are in your landscape, depending on the scale that you want to go down to. But it will also tell you, which ones are current, which ones are in application at the moment, and give you a bit of information as well about the regulatory process and the framework that we have. So I'll wrap up there. These are the details here for our Resources Community Info line. Any questions, any inquiries, please feel free to get in contact with us, either via email or phone. And thank you very much again for your time today. I really do appreciate it. And that's me done. Thank you very much.
Thanks, Steve. Lots of great information there, and I will reinforce the fact that the GeoRes Globe is fantastic to use. So next up, I'd like to welcome Jane Pires, the Land Access Ombudsman. Jane was appointed Queensland and Australia's first Land Access Ombudsman in late 2018 and has also been Queensland's Energy and Water Ombudsman since 2016. As Land Access Ombudsman, Jane's team investigates and helps resolve alleged breaches of conduct and compensation agreements and make good agreements. Please make her welcome.
But thank you very much, Jane, for the introduction and the invitation today to attend and share some information with you all about the Land Access Ombudsman Service. You've heard a lot of information so far about what everyone does, and you can see everyone's got really broad areas of accountabilities and responsibilities that their different departments look after. So just trying to make it very easy for everyone to understand where our jurisdiction is. In the Land Access Ombudsman, we investigate alleged breaches of the conduct and compensation and make good agreements. So they have to already be in place, not under negotiation, but they have to be in place before we can assist. We work hard to resolve the disputes efficiently and informally, and we operate independently of the government. And we also identify and report on systemic issues. So when I talk about operating independently of the government, I am appointed by the Governor in General, and I do not report to any minister. While I sit under DNRME and I am government funded, I actually have that independence to be able to operate and make decisions without anyone looking over my shoulder necessarily to influence decisions that are made. So when a lot of people ask me about what is an ombudsman, what does an ombudsman do, and how do we differ to the other parties in the disputes. So one of my team members has a really good way of describing what we do. They talk about we're a bit like a referee. We're not a judge. We're not a court system. We are another area of alternative dispute resolution mode, and we try to work with both parties to work towards an amicable outcome and to help you produce a long-term relationship and make it a productive one. A lot of the agreements are in long-term, and you need to be able to continue the relationship, and you don't need the dispute that you're working on being something that is not going to be able to work, not going to enable you to work well together going forward. We also look at what's fair and reasonable in the dealings. In our discussions and everything, that's what we're always looking at, working out. Is this fair and reasonable? Is this documentation, the information shared, was it fair and reasonable? Can you expect both parties to understand what you were talking about when you referred to that? So we really look at those key aspects when we're looking to work with you to resolve a dispute. So some of the benefits of coming to the Land Access, it's free, fair and independent. So no party pays any costs towards this service. We attempt to resolve everything quickly, efficiently and with little formality. We do come out to site. We found that going out when we have a dispute, going out onto the property and have a look and understand can really help us form a position and understand what that actually means in everyday life for the landholder and also the resource company. We acknowledge there's dispute resolution clauses in your agreement, but you are able to come to the Land Access Ombudsman without following those processes. And we work on looking at both parties and saving you on time, stress and costs of the process, because we understand that all of those things take both parties away from actually doing what they're there to do in their business. So when I first started in the land access realm, and trying to understand where everyone sat and where could a landholder go to get some assistance. So we've done we call it it's a mud map. So it gives you where you are and gives you the different points of contacts and where the people are and what they can do. So that mud map is available on the website, or you can contact my office as well and we'll be able to send you some through. But it does really give good information, quick and easy to understand where you are in the process of negotiating, starting discussions, and if you've got any issues or concerns. So it's a really good resource and very helpful for you to use or to share with any of your neighbours or families who may be looking at that part as well for their own land access issues. If we go into investigation, we will, as I said, we'll come out for a site visit, we'll have interviews, whether they're face-to-face or over the phone. We will request more information, and we may involve into what we call our facilitation stage. So what we would do is we would come out normally when we do the site visit, but it depends on what's happening for both parties. We will then work with you through the issues and come up with an outcome, a resolution to the issues. And then what we do is we will then stay across the situation and watch to make sure that any of the agreements that are reached to remediate or do any actions are followed through and completed to the satisfaction of both parties before we close our file. So this just ensures that the process works well and it does reach the agreement that we come to. And at the end stage, the outcome stage, We will provide written advice on the parties' positions, and we'll make recommendations on how the dispute could be resolved. So it will document what we've done to date with both parties has been done, or what we think could be done in the future. And therefore that recommendation can be taken anywhere that you may want to take the next step, whether it's to Land Court or anything like that. So it's a very full process. Sometimes it goes quickly, sometimes it can take a period of time. Just depends on what the outcome is. But we work closely with all parties. And as I said, our end goal is to ensure that both parties have a form of a productive working relationship at the end of our process. So what we cannot investigate. So our agreements that are still subject to a cooling off period. So we can't look at those. A lot of people think that you're an ombudsman scheme, therefore you can look at the government legislation, policies or decisions. The Land Access Ombudsman does not have any ability to look at those or make ruling or decisions or judgments on those. We will not handle matters that have now or previously been under investigation by the government or in the court system, and compensation agreements that are part of mining claims or mining leases under the Mineral Resources Act. All of those matters are outside our jurisdiction and we cannot investigate. If we do have anyone that contacts us, though, that falls into any of those areas, we do make sure that we refer them through to the correct area. Just wanted to give you an idea and understanding of some common issues we've seen, either through our investigations or when we've had people contact our office or when we've been out. There have been biosecurity and washdown concerns are always the number one top issue. Damage and disrespect to property or equipment that is, on the land, that's not our top issue, but it certainly comes up a lot more than you think it would be, considering, everyone's understanding of how land access works and also what you need to be doing in your social licence to operate on a person's land. Gate and access issues, so whether the gates are locked or they should be locked after you've driven through and they haven't, that the issues that come out of that and the repercussions can be quite significant for the landholder. Communication breakdowns, that's another very big issue and can happen from both parties. It can also happen too when the resource companies have a change of their team members, and some of those agreements, those informal agreements and arrangements that were in place break down, not referred over or not made aware of by the new land access manager. So those sort of issues can occur quite regularly as well. Failure to set reasonable expectations. So having those discussions, what sometimes can be a bit confronting up the front, be very clear what they are and what they aren't, so that each party is really understanding what everyone expects from themselves. Not doing it as a rule of thumb or, oh yeah, we had a chat once and I said this, and then you've been operating that way for a number of years. But if that message isn't transferred through from either party, that can make it difficult to keep the relationship effective going forward as well. So we are available on our website, and we also right now are currently, with the current environment we're all operating in, we've been setting up some what we're calling our pop-up offices. So we'll have some of our team members come out and spend some time in Chinchilla, Dalby. The next location they're going to Chinchilla, Dalby and Roma as well in mid-September. And it'll be in like a local hall or community centre. So we make sure that we share that information through this group that you're meeting with today, so everyone knows when we're going to be out and about. If you want to come and have a chat with us in a face-to-face environment, we find that's a really effective way to work with people as well. And if anyone would like anyone from my office to come and have a chat with yourself or your team, we're more than happy to do that as well. So thank you very much, everyone, and I hope that's given you a great overview of what the Land Access Ombudsman does.
Thanks, Jane. Okay, last but definitely not least, today's member Peter Stilgoe from the Land Court of Queensland. Member Stilgoe was appointed to the Land Court of Queensland in June 2017. Member Stilgoe has a strong interest and background in dispute resolution and was the first alternative dispute resolution registrar appointed at the Planning and Environment Court Queensland. Member Stilgoe is a qualified ADR trainer, and in 2013 she received the Medal of the Order of Australia for services to dispute resolution. Please make Member Stilgoe welcome.
Thanks, Jane, and thanks everyone for joining us today. An apology first up. My slide deck doesn't have any pictures of rural land, pipelines, or people in akubras. However, there is a picture of a person in a hat. So these are the topics that I'm going to cover today. So there's the picture of the person in the hat. I should say from the outset that the court will make a decision if it has to, and that is its function. In the land access sphere, we will make a decision about what should go into a conduct and compensation agreement. We will make a decision where there are disputes about compliance. We will also make a decision about changes to a conduct and compensation agreement if there is a perception by the landowner that there has been a material change in circumstances. However, we consider ourselves as the option of last resort. Bear in mind that if we have to make a decision, at least 50% of the parties won't be happy. So we try at all stages, even though you've probably been through some sort of ADR process, to encourage parties to consider ADR. So there are two aspects to the court's involvement in ADR. There's the formal top hat and ties involvement, and that comes in three ways. Firstly, under the Common Provisions Act, which Steve already spoke to you about, if parties can't agree on the type of ADR or the name of the ADR facilitator, they can approach the court and the judicial registrar will make a decision about that. We've had a few of those come through to us already since the Common Provisions Act has implemented that. I don't have any statistics on whether those parties have gone on to an agreement through ADR. I mean, it's not a great start that they can't agree on the facilitator or the type of ADR, but that might just be an initial stumbling block. The second way that the court gets involved in ADR is to actually order ADR for a matter that has already been filed in court. So at some stage in the process, if the court considers that ADR is necessary or is going to be useful, we will order that a party goes to ADR. At the moment, the Land Court can only order that parties go to mediation, but again, we can order for a particular facilitator to be appointed. While we welcome suggestions from the parties, because we have access to an ADR panel, which I'll talk about a bit more in a minute, we often have a person in mind who we think will be an ideal facilitator for a particular ADR process. And the third but less common way that the court engages in ADR formally is by a judicial officer chairing an ADR conference. This was quite common when I started with the court 3 years ago. It is less common now because, frankly, we don't have the resources. If a judicial officer engages in ADR, chairs an ADR conference, then that officer can't do the hearing and can't be involved in any appeal. So we're really restricting it to preliminary conferences, which are only an hour or so in length, and generally, but not always, chaired by the judicial registrar who has a facility. He's got a very good record in ADR. In terms of informal ADR or engagement in ADR, so 90% of cases that come to any court settle. And it's really a question of finding the sweet spot of when that's going to settle and helping parties to get to that sweet spot as quickly and cheaply as possible. We have a philosophy in the Land Court that we should always be looking at ways of avoiding the court having to make a decision. Not that we're work shy, we just think that parties who reach their own decision will have a better chance of complying with that agreement or result in the longer term. Section 7 of the Land Court Act also has some information for us about how we conduct our cases. So we're not bound by the rules of evidence. We are bound by the principles of equity, good conscience, and the substantial merits of the case. And we are to deal with the case with a minimum of legal technicalities, without regard to technicalities. That doesn't mean, though, that we will make a decision in a vacuum. While we're not bound by the rules of evidence, we do need some evidence when a party brings a case to us, and we won't act without it. But that's an aside. Going back to the informal requirements or the informal engagement in ADR, because we have that philosophy of equity, good conscience, and substantial merits of the case, we are always asking parties to look for identifying the issues, and we are looking for parties to collaborate in a whole range of things. Firstly, identifying the issues. So we don't have pleadings like a normal court. We will ask parties to put in statements, but from there on, what we're asking parties to do is to look for the things that are really in dispute and focus on them. In briefing experts in our court, we have one brief that goes to the opposing experts. So parties have to collaborate, cooperate, negotiate in relation to what goes into that brief. When the experts themselves meet, they are required to talk over the issues and identify the real issues in dispute. So they are required to collaborate. Once the whole evidence and expert process has finished, then we again ask the parties to identify the issues for the hearing. And that doesn't mean going back to the initial statements and going, yep, we'll just transfer those in and put them in a different document. It means looking critically at what's resulted from the evidence gathering process and collaborating with the other side to determine what's really an issue. From there, we ask the parties to set agendas for the expert evidence. What's really an issue? What does the court have to decide? Alternative dispute resolution. So it's any form of dispute resolution that doesn't require the court to make a decision at the end. But if you have a look at the chart there, the smaller the circle, the less involvement an external person has. So the first and smallest circle is facilitative mediation, and that's where a person, an ADR facilitator, helps the parties to communicate and find their own solutions. It's a very hands-off type of mediation, perfect type of ADR. In fact, the facilitator is working very hard to make sure that the parties understand each other, are communicating effectively, and get to the issues. The second form of ADR, which is the red circle, is evaluative mediation. And that evaluative mediation can only take place with the party's specific consent that the facilitator has the particular knowledge which will assist the parties in resolving the dispute. And what an evaluative mediator does is points out the weaknesses in the parties' cases in private session, can I emphasise, and perhaps predicts the result based on the material that is before that particular facilitator. Now, you might find that that happens in a facilitative mediation as well, but it will happen more by stealth. It'll happen by suggestion. Whereas in an evaluative mediation, the facilitator is a bit more muscular and will be a bit more directive. And that's why I say that because the circle is bigger, there's a bit more active involvement by the facilitator. Conciliation is a step up again. It takes facilitative and evaluative mediation, and it adds the element that the conciliator can propose a solution to end the conflict. It's completely up to the parties whether or not they accept that, but it is a much more interventionist process than the previous two. Moving on to case appraisal, and I want to spend a little bit of time on this because it is a specific option under the Common Provisions Act. So case appraisal is where the parties actually hand the dispute off to a person for an opinion. Now, it can also involve mediation, and we hope that it does. But at the end of the day, what you're doing is asking that person who has a particular expertise what they think the answer should be. That decision, that opinion is completely non-binding, although if a party proceeds in the face of an opinion and doesn't do as well as that opinion when it comes to court, there might be some consequences. The Land Court cannot order case appraisal for a matter that is before it, but under the Common Provisions Act and a couple of other acts, it can order case appraisal. And under the informal ADR involvement, the court can also say, look, I can't order it, but it looks to me as if you've only got one issue outstanding. It might be valuation. There are some really good valuation experts on the ADR panel. Why don't you whip off to them and get an opinion that might resolve it? But as I say, non-binding unless the party accepts that decision. And the final biggest one, arbitration. The parties have essentially lost control. Arbitration is a private court case. You pay for the person to hear the evidence and make a decision. And so all of the infrastructure that the court currently provides for free, the courtroom, the transcribing service, all of those things are paid for by the parties. The advantage of an arbitration is that, unlike a court case, the result is not published. But the disadvantage is that it can be a very expensive process for the parties. But you will have seen from Steve's slides that the Common Provisions Act makes a clear pathway to arbitration if that's what parties want to do. And as I said, there might be some real advantages in that for the parties. One of the great advantages, actually one of the few advantages of our current COVID-19 lockdown is that we have become used to things like this, webinars, engaging over the internet via video conference. So what that does for ADR is it makes it much easier for people with a good internet connection to engage in ADR from their own home or from their office at a time that suits them. But when should you do it? Well, there have been lots of studies on when you should engage in ADR. Some people think that you should do it early when you haven't been concreted into your position, you're a bit flexible about things, and you haven't spent a lot of money. Others say that parties can't really engage in ADR properly until they have better information to make a decision. My view is you should engage in ADR when you're ready, when you have a sufficient mindset, that when you have sufficient information and you are still open to alternatives. And the other thing that I say about ADR is that it's not a one-shot process. If it didn't work in the beginning, it does not mean that it won't work further on down the track, because things change. You get a piece of information that you think, well, now I know this, I can go down that route. Or you might get a piece of information that says things are not looking good. And if I go to court, I'm going to spend a lot of money and maybe not get a great result. Perhaps now is the time to start negotiating with people. So don't be of the mindset that I've done it once and I can't do it again, particularly as you've heard from the other speakers that you'll have gone through an informal process with DNRME probably, with land access disputes. You might have gone to Jane's Land Access Ombudsman and not had a great result. That doesn't mean that you won't have a great result with ADR further on down the track. The other thing to remember is that it's your decision. So don't let anybody talk you into or out of ADR if you don't think that you're ready. But ultimately, it is always something that you should keep as part of your toolkit. So I talked about the ADR panel, the ADR panel of conveners is a group of people trained by a colleague and me, generally speaking. No, that's not true. They are all ADR accredited people. They all also have an extra skill which makes them perfect for the Land Court panel. There are engineers, valuers, town planners, there's a water expert, there are people who are rurally based and just understand the problems and the difficulties that people on the land have, and there are some ex-Gasfields Commission people. You will see, if you look closely on the slide, that we have sectioned them off into regions, so South Queensland, Sunshine Coast, North Queensland, Western Queensland. If you go into their profile, they will tell you where they can go, what means they can do mediation by, whether they can do case appraisal, what their fees are, and again, their fees range from I think modest to, if you pay Rolls-Royce, you get Rolls-Royce service. But they're all really good people. Some of them are listening today, and I'm not going to mention them all because I don't know all of them who are logged in today, but I did see one or two. And so have a look on the ADR Panel of Convener website, find somebody, have a chat to them, see if they're interested, and also if you're looking at ADR, don't discount multi-panel mediations. So you might, for example, get a lawyer and an environmentalist, or a lawyer and a valuer, so that you're bringing different disciplines in, and it all depends upon what sort of dispute you have. Now, I don't have a slide for this, but before we go to the sign-off slide, I just want to put in a plug for our procedural assistance service. So if you're in the Land Court website, go to the procedural assistance service. It is so funky. And if you have a lawyer, it's also a good way to make sure that you are engaging with your lawyer appropriately. You're giving the lawyer the right information, and the lawyer is following a process with which you are familiar. So you won't be engaging your lawyer blindly. You'll have some background information, so you get a bit of a feel for how the lawyer's doing on your behalf. So that's the procedural assistance service. It will walk you through a court case and tell you what to file, when to file, how to file, all of those sorts of things. So it is a fabulous service. It's expanding all the time. We're getting more and more information up, and it's in a very user-friendly face. So have a look at that. Now, you won't contact me through this. You will contact the registry, and the procedural assistance service includes a face-to-face service, so you can ring up, book an appointment with a registrar who will walk you through whatever your problem is, direct you to the correct services, part of the website, whatever. And as with Jane and as with Steve, if we are not the right people to talk to, we will try to steer you back to the correct person to talk to. We don't want people, and I speak for all of us that have spoken today, we don't want people to come in one door, find themselves blocked and get frustrated with the process. There are lots of doors, but they will all get you to a dispute resolution process that is appropriate for your problem. Thank you for your patience today. Back to you, Jane.
Yeah. Thank you, Member Stilgoe, as always, very informative. And now this leads us to our questions and answers session. So we do have some questions, but I also want you to know if today there is a question that you need answered, please just respond back to the registration that you received via an email, and we will definitely get those answers back to you. Okay, so I'm going to follow probably to get from the agenda. So the question today will go back to Des, to you, Kerynne. How many compliance inspections has Des undertaken on the petroleum and gas industry recently?
Thanks for the question there, Jane. So I have it on good authority that over the last 12 months, Des has conducted 63 proactive inspections and 16 reactive compliance inspections of the petroleum gas industry. So when I say proactive, that's where the department will be looking at our own compliance planning priorities and where we want to focus our attention. So officers looking at individual EAs and deciding, yes, that's where I want to go and do an inspection. And the reactive inspections are more when we receive a community report from the public or a notification of non-compliance from an operator, and we'll follow up direct with the operator via a compliance inspection.
Awesome. This is a question that I'm really interested in. So I'm sorry, it's to you again, Kerynne. How does Des consider subsidence when assessing environmental approvals?
Yeah, thanks for the question, Jane. And look, I know this has been a bit of a hot topic recently, so more than happy to answer this one. I guess on a fundamental level, when we're assessing environmental authorities against the legislation, we look at identification of environmental values. So an environmental value can be something like the land, it can be the acoustic environment, it can be water. So the operator needs to identify the environmental values, how their activity is going to impact on those environmental values, and what they're going to do to mitigate that impact or avoid it or offset it. So subsidence is essentially a potential impact on an environmental value of land. So an operator, when they're applying for an environmental authority for petroleum or gas, they need to identify if subsidence is going to be a potential impacting factor on environmental values. And in doing that, they then need to talk about how they're going to, what that impact will be and how they're going to mitigate that impact. And when we're assessing that, we'll look at whether that impact is acceptable in terms of what we need to consider against the legislation. And then that might translate to putting a condition on the environmental authority that manages that activity in a way that manages that impact to the environmental value of land. So there's a bit in that, but hopefully that's of assistance in just explaining how we do things.
I think there'll be more questions to come in that space, but at the moment I don't have any more. So I'm going to cross to you, Steve, as this has come in from a landholder, and the question is around the Land Access Framework 2010, specifically around restricted land. I've got a couple of questions in relation to this, but the first one being, does the restricted land framework apply to tenures that were granted prior to the commencement of this framework in 2016?
Right, thanks very much, Jane, and thanks to the question. It's a great question, and I guess like all great questions, the answer is not necessarily straightforward. So the restricted land framework that I mentioned in the presentation there, and I should say more information around that is available in the Guide to Land Access in Queensland documents. I would again recommend everybody have a look at that. It doesn't apply retrospectively. So what I can say at the moment, in terms of restricted land, new potential restricted land can be added during the ATP or the exploration phase. The cutoff at the moment is generally where the application for a production lease or a petroleum lease goes through, and ultimately if there's any disputes around whether something is restricted land or not, then ultimately it could be determined through Land Court. in terms of pre-framework, as you'd be aware, over time there's different changes in legislation that always occurs. So we'd need to understand, I guess, a bit more about when that tenure was in place, to be able to get a bit more of a solid response there. So, for example, there'd be particular provisions that apply after the Land Access Framework came into place in late 2010. Similarly, prior to that, it may well be captured within a property access agreement, for example. So we need to look into that a little bit more.
So what does that mean for neighbouring properties?
So in terms of the, thanks for that. So in terms of the restricted land framework, it doesn't, I guess it doesn't acknowledge property boundaries, so it works outside of those. And so, for example, if you have if you're on, say, 50 metres away from a neighbouring property, then a well, for example, then that would need to maintain that minimum distance as part of that. Even though it's on a separate property, it would need to maintain that minimum distance that in this case 200 metres that the restricted land framework provides. So, and that also applies to the tenure boundary as well. So if you're outside the tenure boundary but within that amount of distance captured under the restricted land framework, then it would still apply there.
Okay. Sorry, Steve, it's like I'm picking on you, but there's another one. Where can I find the date on which a petroleum lease was applied for?
Right. No, great question. And look, I've got hopefully a good answer there, because I mentioned a little bit earlier the GeoRes Globe. So it's a fantastic tool for looking into or mining data exploration. All of that information is all there. So, and this is a case where it's quite simple to go in, have a look at whatever resource authority, whether it be exploration or production, and amongst a whole raft of other things that it has available, you should be able to search for that ATP or PL, as we call it, and identify which one it is, and then there would be information that would come up on the screen, and that would include lodgement date, granted date, and the expiry date that would apply to that resource authority.
So will that also, on GeoRes, will it also show when the petroleum lease was approved? What date? What year?
Yeah.
Okay.
Yep.
Cool.
It would typically private. Yeah. I guess the caveat in there would be if it's potentially if it's a very old lease, but so I guess in that space, I think it would probably still capture it, but I don't want to be absolute on that. But okay. Even in those situations, if there was ever any occasion where that information wasn't there, I strongly suggest get in touch with the Resource Community Info line. We'll do that checking into it, and we'll get that information back to the inquirer.
Thanks, Steve. I'll leave you alone
no
now.
Worries.
We're going to jump to the Land Access Ombudsman. I think a couple of these questions have already been answered, Jane, but I will ask this question, which is, can you receive disputes from both farmers and resource companies?
Thanks very much, Jane. Yes, absolutely we can. And to date, the matters that have gone into investigations, they've been initiated by both 50% both ways. So, and we also do, but we do get a lot of calls and inquiries do come through from landholders. They're just general discussions more so. And we do get a lot of contact from people that it's absolutely nothing at all to do with what we can do here in Queensland. We regularly get contacted from Victoria and Melbourne wanting to resolve land access disputes in the cities. That makes it's a great conversation just to understand what their issues are, but they're not anything we can help with. But yes, we can take disputes from either party.
Great. So, and just a final one for you, Jane. Sorry. What do you mean by assessing the merits of each party's side of the dispute? How does that work?
So what we do there is we will do a thorough investigation of all the information. We'll have discussions with them and really look at everything to really try and understand what the root cause of the problem is as well, not just looking at what the issues are that we're trying to resolve, but what's caused it and how can we provide recommendations or suggestions of making sure that the similar type of situation doesn't occur again in the future. So it's really doing a thorough assessment to make sure we get everything out from both parties of what the issues are. And particularly too, sometimes there'll be matters we can handle and sometimes we can't. So we then would refer them through to the other people that are here on the presentation today. It might be something we handle some and we put some through. This issue needs to go to the Land Court, so we'll refer them through to the correct area in the Land Court. So it's providing that full information for anyone that contacts us.
Thanks, Jane. Now we've actually coming to the conclusion of the webinar today, so I want to thank DNRME, Des, the LAO and the Land Court for your time today. Really appreciate it. It was very valuable, great information as always. And I hope all our participants have taken away some form of understanding where all of these organisations sit. Please, I reiterate, if you have not received an answer to what you would like to know, send me an email. If you know my phone number, text me, or please reply to the registration email and we will get that information back to you. But I also want to say, keep an eye on the Commission's social media accounts for more detail on up and coming webinars. This is only the beginning. So don't forget to subscribe to the Commission's YouTube channel to view today's and all future webinars. So with that, I'd like to thank you all. And in closing, I want you to understand that there is no wrong door. I was waiting for Jane and Member Stilgoe to say that. They both normally say that in their information. Please contact us. We will point you into the right direction. So thanks again.